So with me is Bob Hilla and Michael Koribanics. I knew I'd get that wrong, Koribanics.
That was close. It was very
Darn
good.
it. And you guys can help me break this down. Let me ask you that. First of all, why wouldn't an expert witness not want to be seen on camera? I just don't understand that.
I think sometimes people get camera shy. Obviously, none of us here.
Of course.
But I think sometimes witnesses don't want to be put out there as, hired guns, that type of thing. Some people like to maintain their credibility in a courtroom. I really don't know why this witness, maybe just a fear of drawing attention to themselves. I don't get it either.
So Michael, tell me, what do you want to know about Dad before you can feel comfortable saying, the prosecutor's proven the case?
I think this cross, getting to that, is a little bit of a tightrope walk for a defense attorney, because I'm teetering between whether or not, I know he's maybe feisty or aggressive, but I'm not so sure if he's being really effective, because there's a danger between being effective and walking your client into a problem. I think with his back and forth with this expert witness, he's causing a problem that may work against him. You see, you have a horrible victim here, a 3-year-old. That's and what he's getting across is that this child might have been abused by everyone across the board, as I'm looking at it. And I think he's getting into some fights that may come back and spill over onto his client and have some heavy prejudicial effect, because she may be abused by the father many times prior to the babysitting incident. But the bottom line was the last person in her control was your client. So you better watch how you portray the father, because if you go overboard with it, it could spill back on you, because they're going to wonder, why didn't she give as the babysitter? Why didn't she call the authorities? Why wasn't anything done if she noticed all these injuries?
If she didn't suspect anything. I got you. And, again, I think the dad and what he did and what was going on in 2/3 of this girl's life is critical, and we're just now starting to hear a little bit about that. We will keep our ears perked for that. Michael, let me ask you this, because we've been talking about the dad, what he did do, didn't do. You're sitting on that jury. Don't you want to hear from Dad?
It's perplexing that, as a former prosecutor, way back when, it makes me very curious, and I'm sure it makes the jury curious, is you have a victim's family member who you'd always want to put before the jury to let them know that the actions have an effect. But not only that, you have a victim's family member who actually is being brought up a lot during the expert testimony, and you'd think you'd want to put them on the stand, because you have the burden of proof, to sort of get away from all this innuendo as to somebody else causing it. It's very curious to me that the state is not putting the father on the stand. I think they're making a grave mistake, but then again, I always say that you really don't judge the way people are putting on cases, because you don't have their file, and there may be a very good reason why they're not putting him on, because he won't make a good witness.
Yeah, that's very possible. We've seen a little bit about where he and the little child were living. Didn't look like the Ritz. I wouldn't judge him on that alone, but it sure raises questions, right, guys? How do you feel about the back and forth there between the expert and the attorney?
Well, I think the attorney is losing a little ground here. Cross-examination is all about the control and pace and rhythm of your questioning. And he's allowing this witness to really, almost at times, she sounds like she's giving the summation for the prosecution as to why she didn't do her job. I think he should go back to being a little more aggressive if he wants to be effective, and stopping her and telling the judge to have her answer the questions. I think when she said one thing there, and I was surprised he didn't go off script, for lack of a better term, when she said, well, I don't know the law, but I know what lawyers tell me. My next question would have been, well, what did the lawyers tell you to say here? Because now she's really starting to sound like a hired gun who's been prepped to say certain things to get her expert opinion across.
Yeah, exactly. And obviously what the expert is told and what they're asked to do in their report is critical. We were just looking at some of the brain scan images there. And on one of them, you can see on the one that is screen left there, far left side of the skull, there's actually like an island of sorts. That's where a piece of the skull was actually detached as a result of some injury at some time by somebody. And then during the surgery to release the swelling on the brain, they removed that little piece of the skull. Again, be great to have an idea of how that was caused, what kind of injury, what kind of trauma, what kind of force. I'm not sure we've heard that yet. What does a jury do with that? Let me ask you, Michael.
Oh, I think they're going to have, like Bob said, if they don't tie this together with the expert, I don't even know if the jury's going to have to make that decision, because I think the judge is going to pull the case away from the prosecution until, because I don't mean to jump around, but one word that really, there's a jury charge that says you cannot convict someone on mere conjecture or speculation. And when you have an expert using the word expect, I mean, I expect, Christmas to come early this year. That's speculation. You don't want an expert who expects. You want an expert who says, this is what's going to happen and this is what happened.
So the jousting continues there between Dr. Makarov and defense counsel. This is cross-examination of the prosecution's expert who, guys, Bob, Michael, I've still yet to hear direct causation testimony or negating causation testimony. I'm hearing picking at various injuries and her opinions. And I got to say, Michael, her opinions are a little meh. They're not very strong.
Well, they're not very, obviously the one part of this cross-examination that has become effective is she's really on her toes. She's almost overthinking every answer.
Is she too defensive?
Much too defensive. Okay. I mean, when you say significant, I don't know what you mean.
She's parsing everything.
And that, to me, you lose credibility with a jury, because now you're like not confident in what you're saying. You're not coming across as an expert.
Okay, so if that is the case, I mean, it seems to me, my defense, closing argument begins with, hey, there are a lot of holes in this case, ladies and gentlemen of the jury, and it's not your job to fill those holes. It's not my job representing the defendant to fill those holes. It's the prosecution's job. And you know what those holes are? Reasonable doubt. And it's not, a hole that your little toy train with an 8-inch drop drives through. It's a hole that a Mack truck drives through. These are big problems, I think, for the prosecution. Michael, what do you think?
I think your whole summation would probably have every 10 words would be burden of proof, burden of proof, burden of proof. I think it's as far as how do you rehabilitate this witness, maybe best thing for the prosecution to do is let them finish the cross, get her off, and just keep moving.
Really?
I sometimes think extensive redirect really bolsters the credibility of the cross-examination. That tells the jury you were hurt.
You had something to worry about.
You were hurt, and now I got to clean it up.
Okay, I got that. Michael, what do you think? I mean, is she hurting herself? She certainly doesn't seem to be helping the prosecution.
She's absolutely destroying the prosecution. I mean, as I've been sitting here through this hour, it just seems to be getting worse and not better. And it's to the point now where, at least at the beginning of when I heard her testimony today, she was at least talking about something that had to do with the case. Now she's playing right into the cross-examination's hands, because she's talking about everything but the case. She's talking about her book. She's giving herself self-promotion. I think if they show the book one more time, she may want to go on camera with a picture of it and see if she could get some sales.
Yeah, that is an odd contradiction that, she seems to be willing to perform, but doesn't want to be seen. And if we are getting toward the end, Michael, we've mentioned this a little bit. I still think that somebody's got to hear from the dad, either directly or indirectly. Is there enough for them in summation for the prosecution to fill the holes they need to fill?
I don't think so. I think they're going to have a really tough road to travel. And really what makes me even more convinced is earlier in the show today, we listened to that 911 call. And, under the rules of evidence, excited utterances, things of that nature, there's even jury instructions. You can give them great weight because they have more credibility, right, because they're happening in the moment. And it seems that 911 call, even if you're going to have to compare it later with her statement, sure throws a lot of the burden away from her and onto the father, basically saying, this is the way I received the child. And when I received the child, the last person who had that child in their custody was the father. And the jury's going to be looking around to,
where's Dad? Where's Dad, and what's going on at the dad pad? Because she's there roughly 16 hours a day, all weekend. But, I think she is somewhat likable, but she also gets a little testy. And there's a fine line that the jury would cross over. At a certain point, they may say, calm down, enough already. You're so upset, maybe we shouldn't believe you.
Well, you see, I think a big problem as an expert, although they're for a side, once they start getting into it with the attorney and start explaining their answers before they're asked to explain them, I think it makes it look like the best defense is an offense. It's like, gee, you're here to answer questions. I'm actually surprised the judge hasn't jumped in this case and instructed the witness to just answer the questions, stop being argumentative.
And we haven't seen a lot of objecting, really, on either side. Yeah, and obviously, Michael, you're not going to blame the babysitter for the Hep C. She's off the hook for that. So if you're the defense, you can use that.
I think if you're in the defense, you use it, you hold on to it, and you ride it as long as you can. I'm a little surprised that the prosecution didn't object to those questions coming in as being really irrelevant, because you have an expert who says it's irrelevant. She says it in her book, it's irrelevant, and it's not in the case. Had she said maybe that there was a trace of it or there was some sort of scintilla of scientific proof that you could bring it forward, then I think maybe the defense would be allowed to go into it. I just think under a real balancing act that the probative value of those questions against a prejudicial value, I can't believe a judge really would let that in.
And I think if they'd been maybe enough foresightful, that might have been a motion in limine, if it were to come up at some point, because now it's really too late. Once that question comes out, even if you ask for a sidebar and then you talk about it and the judge says you're right, we're not talking about that anymore, that's almost a bigger problem. Now you've hung the Hep C balloon out there and the jury's left to figure out what it means. And it's probably not good in terms of impact on what this jury thinks of how Hannah was injured. Let me ask you, Michael, about the cops on the other side. The good cop, the bad cop, the screaming cop, the friendly cop. This guy's kind of antagonistic. We know it was an accident. We know it was. Just tell us what the accident was. How do you think that plays to the jury?
Not very well. This is a video I'd use to show police officers how not to interrogate. I mean, if you look at even the body language, physically, the younger detective or police officers at the edge of his chair, he's in her personal space. He's saying, like you said, who yells at someone, this is a horrible accident? I mean, you talk about the body language saying something different than the words. That's a classic example. I don't think this plays very well, and it gives a better explanation to the defense as to why this young lady who just underwent this traumatic event is saying so many different things, because she's absolutely being bullied.
Well, thank you, Michael. I appreciate that. Thank you for answering. We'll come back in just a couple of moments. We'll be in the courtroom if the jury is brought back into the Lindsay Partin case. So, Michael, when you hear her admit to that kind of physical contact, which way do you lean? If you're the jury, do you listen to that and say, boy, she did it? Because I know she shook this child. Or do you say, hey, she's a babysitter, she had to discipline to a degree. We understand the dad said it was okay for corporal punishment to some degree, I guess. What's the jury do with this?
Like I said, I'm grasping the 911 tape. I'm arguing to the jury that was a spontaneous, instantaneous statement that really has the ring of truth. All these other things were coercive settings with the police, and maybe she was just trying to tell the police what she thought they wanted to hear because she had just gone through such a horrible event. And at the end of the day, you hope that the jury, if you're the defense, says, there's so many different stories here, I don't know what to believe. And if you have that, the prosecution doesn't meet their burden.
And so she's now saying, this other story emerges, that she believed that Hannah was having a seizure at the time. We didn't hear that storyline, Mike, before.
I'm not a big believer in admissions and confessions, as police are coercive in most of the time.
Did you think those police officers were coercive?
Yes, I do. I do think all these things have to be placed in context. I would be, and I would cling on to, as I've said earlier, the 911 call.
She sounded desperate.
And she also sounded like she was saying things as they were happening. Here now, she's in a different situation. She's accused. And the interesting thing is, why don't the police say, why did you say this on the 911 call? Why did you say this? Why didn't you mention that? So they're sort of now putting her in this coercive context. And I don't think anything she says after the 911 is reliable.
With the murder, Mike, you have to show that she intended to kill this child.
Yeah, there has to be a specific intent. That was her intent. It doesn't appear that there's anything even near that here. At best, you'll have reckless indifference to human life. At best, but I think that's a stretch.
Yeah, I don't think jurors are going to see that this woman came out with a mission to kill this child here. If anything, it was extreme negligence. But again, then she is admitting to hurting the child. But that's two different stories here, right, Mike?
Well, they're two different stories, but they're in a position where she's getting, it's not like they're telling someone who's caring for the child out in the hallway or things like that. I mean, the jury's getting a sense of how coercive a police interrogation could be, and you have somebody talking to you and throwing out things, and you're just trying to answer because you just want to get out from under. Even if you didn't do anything, it's intimidating.
Really quickly, guilty on the top charge murder, Bob?
I don't think so.
How about you, Mike?
Not guilty.